And Marc, this first question is for yourself, but it's open to all of our panelists as well. But Marc, what are the risk mitigation strategies merging parties can use if they believe their proposed acquisition involves a nascent competition issue?
Yeah, so the first strategy is way broader than just nascent competition issues, and that is you have to work really hard on document creation, so that you don't get documents that basically are red flags, basically where the acquirer in this kind of particular case is saying, I need to take this party out of the market because they're going to be a challenge for us in the future. But that kind of thing is important all across the board. The second kind of thing you can do is prepare in advance. And the advanced kind of preparation you want to do is preparation to show the agency this is not a matter that ought to get a second request because they really don't fit the profile of a nascent competitor. I think one of the most important things you could say under the circumstances is the folks we are acquiring are not unique. There are plenty of other companies out there that could expand rather than and they are the equal of the firm we're buying. You can turn around and basically try to show not only are there equals out there, but that you get some substantial efficiencies by doing this acquisition, and that's the reason you did it. So I think those are the kind of things you want to do to prepare for a nascent competition case in the hopes of stopping it in advance. I mean, one of the last matters I did, before the FTC, I had 5 white papers almost completely prepared before we ever talked to the agency. So that can be a way to go depending on what kind of matter it is.
Thank you so much, Marc. I think this final question, it dropped in during your segment, Dan, but it's open to all of our panelists. Do you have any general tips for parties that may want to litigate a proposed fix, Dan?
Sure. That's a very big topic. If you have a divestiture, if it's a structural remedy that you're trying to litigate, it would be best for you to have the buyer signed up, have everything kind of locked down and ironclad. I think one of the things that came through in a recent case from a few years ago that we haven't mentioned yet, and this is the Aetna Humana case, where they had a proposed divestiture that was very large, and a proposed buyer was the judge in that case, Judge Bates here in the district, shot that attempt to litigate the fix down largely on the basis of an inadequate buyer. So the buyer had a number of unfortunate, from Aetna and Humana's perspective, unfortunate emails saying things like, I believe there was one from a board member of the buyer about, well, we're like a dog and chasing a Suburban. What do we do if we catch it? And which doesn't speak well to their ability to run the business post divestiture. And so, one of the things that I think, if you have time and the ability to do it, it would be good to make sure you're vetting the buyer and perhaps try to do some diligence on their documents after, there's going to be some sensitivity there, but there may be ways to do that so you ensure that you're not undercut by the buyer, even if you have a great asset package to sell. If it's something short of a compelling set of assets to divest, so if it's a behavioral remedy, I think you want to work to make it as binding as possible. So you notice the language that Turner used about irrevocable irrevocable nature of their offer, etc. I think that helps at the margins. I think getting it out widely, proving why it's in your incentive to do that anyway. And then finally, on a more, I'm cutting this short because I know we're at time here, but I would resist the bifurcation provision that DOJ may be seeking to put in their case management orders, as I think that is detrimental to merging parties.